with their finger on the pulse. So the more questions that the attendees want to ask, the better. There is a chat function. If you look at the bottom of your window, you can click on the chat window, send your questions that way. We will try to answer them in real time. So if you've got a question specific for Judge Groner, Judge Ackert, Mike Jolet, make sure you indicate that in the question, and we'll try to answer them in real time. If not, obviously we've set aside some time at the end to answer any questions we don't get to. Initially, this webinar was going to be about remote jury trials or jury trials since the shutdown in March. Everybody on here knows there's probably been a handful of civil jury trials in the entire state since March. So because it became clear to us that that wouldn't necessarily be appropriate, it's kind of morphed into a discussion about Zoom and remote hearings in general. I believe Judge Ackert has actually had some bench trials over Zoom. Judge Groner conducts probably 70 hearings over Zoom every week, if not more. So it's going to be kind of a discussion and perhaps some insight into the future of litigating these civil cases in Michigan, at least while I guess we wait for herd immunity or the vaccine. Again, if you've got any questions, type them in the bottom. We'll try to get to them. So at this point, I think we're just going to introduce the panel members, and we can start with Judge Groner of Wayne County Circuit Court.
Okay, well, first of all, thank you, John and Mike, for inviting me to be on this webinar. These are tough times, and you two have done an outstanding job in helping the lawyers get through this kind of situation. Zoom has been a godsend, in my opinion. We're lucky that we have Zoom. I know Judge Ackert will probably speak to this too, of course. And the biggest challenge, I think, for all of us is, since this is all new to all of us, even though it's been 9 months, there really are no kind of rules. It's like every court is different. Everyone's doing different things. The motion schedule is so different than it used to be. A lot of judges are making rulings without hearings. So many different factors. Motion calls are on different days with certain courts. I've been doing a full motion call for almost the full 9 months. We just do Zoom motions on Fridays, and it's been going well. But of course, there are a lot of challenges. We can't set trial dates now, and that's really the biggest problem. So just to touch on the Zoom trial dates, as of right now, the latest in Wayne County Circuit is the earliest trial dates will be March 15th, and the earliest bench trials would be February 15th. And that was back in December. Those are the dates set by Judge Kenny. And obviously it's a moving target. We attempted to do some jury trials in Wayne County, but because of COVID and other issues, they didn't go. So there were a couple of jury trials, I think, in the criminal division, but nothing in the civil division in Wayne County. And what I'd like to talk about today, later on, with some questions, hopefully a lot of questions, and we're going to leave a lot of time for questions, is what can the courts do to make your lives easier as lawyers, and maybe, hopefully, what can you do to make the courts' lives easier, and how can we work together? Because Zoom is here to stay. Vaccine or no vaccine, we are all going to live with Zoom. The Chief Justice, Bridget McCormick's done an outstanding job in making sure that the Zoom technology is available for us. Tom Boyd, the court administrator, has sent out memos about Zoom and how important Zoom is, and how we should defer to Zoom as opposed to in-person hearings. So this is something that's very important to the Supreme Court. And I think the reason why it's so important to the Supreme Court is not because of the convenience for the judges and the lawyers just to get on a computer. It's about the public. It's about the fact that the public doesn't have to come down to the courthouse, get in the car, come down, go through security, and waste a whole day or a half a day for a hearing other than a trial where it could be done by Zoom. And that's the main reason why I think Zoom is being promoted so heavily in our courts and other courts around the land. So with that being said, for those of you, I should have introduced myself. For those of you who don't know me, I'm a Third Circuit judge in Wayne County. I've been a judge for, well, since 2003. I was in the criminal division for about 11 years, and I've been in civil about 6 years. So with that being said, I don't want to talk anymore now, but I hope there'll be a lot of questions later on, and I'm sure I'll be chiming in later on as much as I can to answer questions and to hopefully help out in moving forward. Thank you.
So, Judge, thanks, Judge. Judge Ackert, do you want to introduce yourself?
Yes, thanks, and I appreciate the opportunity to join everyone on this webinar or conference. It's timely. There's lots of questions being raised, and where are we going to go? I agree with Judge Groner in that Zoom is here to stay. How that's going to look, where we're going to go with that is things that I'm looking at with a committee we call lessons learned, is what has transpired in the courts since the pandemic. I co-chair that committee with Judge Groner's colleague, Judge Patricia Fassard in Wayne County. We were appointed by the Supreme Court in Scale. We have a number of judges on the committee. We just recently had about an hour and a half conference, I'd say, with Mike Jolet and Terry Durkin regarding MDTC's input on the issues that we have relative to Zoom. We started looking at these issues back in April. We have been looking at whether the courts were ready for this emergency, to how did funding sources work with the courts, sheriffs, and the jails and the prisons working with the courts, the various issues regarding access to the courts under the pandemic, and then also technology, which we're talking about today, which is Zoom. And lots of interesting trial or anecdotes out there about Zoom hearings, but the Zoom has been very beneficial to the court. Chief Justice McCormick is adamant about always exceeding where we are now in terms of access to justice and providing service. I commend Scale for having the foresight in 2019 to start securing Zoom licenses. Had that not been done, we wouldn't have been as quick to speed on Zoom as we were. And as it stands now, Michigan is the #1 state in having the most hearings by a virtual interactive platform, which is Zoom, throughout the country. The most jury trials have been in Texas, but they have not been by Zoom. There's been a few jury trials down in Texas, but they've been a little less concerned about COVID down there in terms of running jury trials, but they do it in gymnasiums and so we're struggling with the criminal side of the pandemic and trial access, but civil side's been moving along. We've been fairly close to the numbers that we were hoping to meet. So the courts have been working, and you've all been involved in that. So happy to answer questions and talk about what I think the courts are going to be looking at in terms of Zoom and where we go from there.
Thanks, Judge. And even though probably everybody attending knows who Mike Jolet is, I'll let Mike introduce himself.
Thanks, John. First, I'd like to say thank you, obviously, to Madeline and Matt for helping us as far as setting up the virtual seminar, or the ability to do so. I think it's pretty ironic that we're talking about Zoom and the future of Zoom as we're actually doing these seminars via Zoom. And the ability to get more attendance and the ability to get more people involved. I think it's a lot easier doing these types of things virtually. And I'm not saying I prefer these, I prefer to be in person. In fact, I assume most, if not all of our attendees who are attorneys do likely prefer in-person seminars and things like that so that they can, kind of, communicate and get things going. But first, again, like I said, I want to say thank you to the MDTC, the executive board, John Hohmeier specifically for helping get this thing organized. I think this is probably the most excited I've been for one of these types of events. And maybe because it's not necessarily substantive, right? There was a lot of things we had to do to get prepared for this type of an event, but not much substantive when it has to do with law, cross-examining, a lot of those types of things. It's more of a procedural type event, but I'll tell you what, I know Judge Ackert and I had a long conversation the other day, and it was the first time I had a chance to meet him. So it's an honor and a privilege for Judge Ackert from Kent County to join us today. We really appreciate it, especially the input that he's going to be able to provide. Feel free to ask questions to both of our judges. Judge Groner, I'm sure one of everybody's favorite judges on the line, is always willing to help or communicate. We reached out to him. I think John reached out, and it was the fastest yes, and it was the most fun I've had, Judge, preparing for one of these things. So sincerely, on behalf of the Michigan Defense Trial Council, both judges, thank you both. Some of the areas that I want everyone online right now to kind of know about is when we got together to talk about this, this is not a lecture by any means. If you know the panel, you'll know that none of us like lectures and none of us are good at them. So please, cooperation on our part will be 100% if we see some questions. We want participation as much as we can possibly get. Criticisms, I think Judge Groner is amazing at accepting criticisms of the court. Let's try not to make it of him personally. But of the courts, that would be great. Questions, concerns, thoughts, things like that. Areas that I think that we're going to be touching on, at least for my portion of today, will be pros, cons of the virtual hearings, settlement conferences, motion call. You'll hear discussions that I hope we can start on what types of motions do we prefer for Zoom? Are there motions that are just very difficult to argue via Zoom? What's your preference when it comes to settlement conferences? Are they in person? Things like that. These are the areas that I think that I'm going to be trying to elicit questions and conversation. And then I think more importantly, the practicality of the matter. Let's be honest, defense attorneys out there are going to see a massive change to the way they do business. There were times when you had to find coverage. If you were in Judge Ackert's court or the building in Kent County at 9 o'clock, you pretty much had to mark off that entire morning or day. You certainly wouldn't make an appointment to argue a motion for summary disposition at 10:30 in front of Judge Groner. Zoom has opened up a new book. The comparison that I tried to draw, which is a very dangerous comparison, so please do not read too much into this comparison, but obviously as a society, from probably the beginning of civilization, tragedy and pandemics, things like this change the entire world, specifically certain types of businesses forever. We can make the correlation between 9/11 and if you've ever walked into an airport after 9/11 or security after 9/11. Again, I don't want anyone on this committee or in the audience to believe I'm trying to compare COVID with 9/11 or vice versa. I'm simply indicating that this is an interesting time period because let's face it, the judicial system, the practice of law has had to grow up and has had to move and advance from a technological standpoint light years in just a matter of months. And I think that it's going to be for the better. And I think that it's these types of meetings, these types of discussions that will guarantee that the judges the clients, who I know I've seen some in the audience, so I super appreciate you hopefully chiming in on this topic. But when we all come together as a group and bring these great ideas and these mindsets and the criticisms and the compliments, I really think we can kind of make the best of a terrible 2020 as far as pandemic. I think we can do a very good job of moving forward into the future. So thanks to the panel, thanks to the attendees, thanks to the MDTC, and John, I'll turn it over to you for further discussion.
Sure. So yeah, I'm John Hohmeier. I'm a lawyer at Scarfone and Geen. I suspect that I'm the only reason I'm on this panel is I think I tried one of the only in-person jury trials in the Tri-County area since March. It was in September in Macomb with all the proper social distancing and safety procedures, masks. We'll talk about that as the day goes on. But I think we can start with some just general observations about the explosion of Zoom. And if we look back at 2019 compared to 2020, we switched from essentially hundreds of jury trials a month, if not a week, to essentially no jury trials at all. And as Judge Ackert pointed out, a lot of the trials are occurring in Texas. So there's no real data to be drawn from Michigan courts yet. But I did find a great article by David Slayton, who's the administrative director of the Office of the Court Administrator in Texas. And he set out some pretty clear data points, suggestions, recommendations, things that went right, things that went wrong. And those of us that litigate these cases, these civil cases, especially in Michigan, can kind of see the parallels. So I'm just going to kind of go over a timeline here and the progression of the progress of Zoom and jury trial. So for example, prior to the pandemic in Texas, they averaged 186 jury trials a week. Once trials were finally permitted in Texas, which I believe was in June, they've had 20 trials. Between June and through September, only 2 of those were civil cases. 18 of them were criminal, only 2 were civil, and both parties agreed to go to trial. If you look at the Texas population, it's about 29 million. Michigan's about 10. So if you keep that ratio in mind, it pretty much parallels Michigan, because we only know of a few trials that have even happened in Michigan, and the vast majority of them have been bench trials, not jury. We're aware of, I think, 3 jury trials in the state in civil cases since March. So if you go back to March, and if you look at the state Supreme Courts around the country, Texas, Michigan, and others as well, they began issuing orders suspending all jury trials through May, and then June, and then July, depending on the state. Part of the orders, however, were directed at the courts to begin exploring various technology platforms that would allow courts to do remote proceedings. Anybody who does federal cases knows that everything's done over Zoom. Anybody who's doing state court here in Michigan, everybody's doing it over Zoom. Zoom is being used in Texas and every other court state. So Zoom obviously won that out. But again, for example, Zoom has allowed us to continue litigating these cases and essentially keep these cases moving forward, keep the justice system moving forward. But if you look at, so for example, again in Texas, the week of March 16th to 20th, which is pretty much the same as here in Michigan, Texas started, they went from basically no remote hearings in any court on any level. They conducted 100 remote hearings the week of March 16th to March 20th. By the end of August, they were conducting 110,000 remote proceedings per week, with accumulating nearly 400,000 hours of hearing time. And that's per week. Like Michigan, obviously on May 20th, Texas implemented a jury trial process, which included both parties having to agree to actually proceed to trial. How that worked out is exactly how everybody thinks it worked out. It didn't work out because either one side wanted to go and the other side didn't, or neither side wanted to go. They didn't want to waste their time being the guinea pig to see how these jury trials would go during the shutdown. That was eventually eliminated, and they eliminated the consent requirement. But what they did do is allow parties to brief their objection, why they didn't want it to go forward, and if necessary, file interlocutory appeals. So in Michigan, it's kind of been that way, but for example, the case that I tried in Macomb, both parties filed objections. There was no time to conduct any type of interlocutory appeal, and the court just basically greenlit the process, and we conducted Zoom voir dire, actually, and I'll get to that later. And then there was 2 days in person in trial. But if you look at the numbers in Texas, again, between June and September, they had 20 total trials. Only one of them was only 2 of them were jury trials. One of them resulted in a mistrial. 13 verdicts were reached. 1 resulted in a plea deal, and then 5 were continued into September, October, which they don't have the data for yet. And these are just some observations that have come out of the courts there that have been conducting trials, whether it be Zoom or whether it be in person. So there were about 2,700 civil jury trials in Texas in 2019. If you look at Michigan, it's probably about 1,000, maybe more, because we have obviously the No Fault Act that perpetuates tons of litigation. And then between March and 2020, there was a handful, and that's been the same in Michigan. When the court administrator first began their protocols in July, again, consent was needed from both parties, but they found that they couldn't get consent from both parties. So what they were going to do is just try to push cases through that had to be tried, major felonies, capital murders, stuff like that. There is actually a traffic trial in there somewhere that was conducted over Zoom. It was the first jury trial over Zoom, I believe. But with regards to jurors, they saw about a 10% drop in people showing up when they were subpoenaed for jury duty. And then of the people that showed up, there was an additional 10% that requested to be excused for either health reasons or COVID reasons. It seems that judges were pretty liberal in allowing people to excuse themselves if they wanted to. At my trial in Macomb in September, none of the jurors that showed up asked to be excused. And actually, when we pulled the jury after the trial, at least 2 of them had health concerns, pre-existing health conditions. And they said that while they were concerned about the lockdown, the pandemic, and their pre-existing health, they felt that their civic duty to sit on a jury actually outweighed their concerns about COVID. So that was a little surprising to me. Fortunate, but a little surprising. Other things the courts are noticing is that the location of jury proceedings is always going to be an issue in courts that have limited space. And anybody who's tried a case knows, when you sit these jurors in a box, there's almost no box that I've seen in any circuit court or district court that could hold 8 jurors with the appropriate social distancing measures. When I tried mine in Macomb, everybody who knows the Macomb courtroom, they have the huge gallery behind all of the lawyers. That's where the jury sat. So they're about 20 feet away from any potential witness. They were behind the lawyers as the lawyers was asking questions. And part of getting through that was the court put televisions in the gallery so that the jurors could see the witness, they could see the exhibits, and then there was also speakers in the roof that would allow them to hear the witnesses and the questioning. But that's obviously going to be a problem with any court that tries to conduct in-person jury trials. Zoom trials are obviously totally different. Everybody's in the safety of their own home, but then you run into technology issues. And of the 3 trials that were conducted remotely in Texas, none of the problems related to COVID. They all related to technological issues like jurors couldn't log on, they couldn't hear, there was a major time delay, stuff like that. Face coverings was a major issue because for a while in Texas, they were not required. And then Governor Abbott issued a order requiring them. I think in Michigan, we've had them required since, I think it's April or May. So for example, again, in my trial, everybody in the courtroom, including the lawyers and judge and the jurors, had to wear face masks during the proceedings. The only people who were not wearing face masks were the witness at the time they were testifying. And then when they left, they had to put it back on. I think that would have been the plaintiff only. But both myself and the plaintiff lawyer objected prior to trial on that aspect. And that seems to be one of the biggest points of contention when trying jury trials. I mean, it's hard to develop a rapport with the jury during voir dire when you've got a face mask on and they've got a face mask on. You don't know if they're laughing, you don't know if they're smiling, you don't know if they're looking at you like, what are you talking about? So that was one of the biggest issues I saw, and I'm not a big face masker in general, so I found I was fidgeting with it a lot. But that seems to be a lot of the observations that have been coming out of at least the trials that have been going on in Texas. And certainly from my experience and a couple other people I talked to who have tried cases here since March, that is a concern here as well. So you can see a lot of the parallels between Texas and Michigan, even though we don't have all the numbers yet. We do have a question here actually coming, and I'm gonna send it to one of the judges first. If you've got either a person in front of you or a judge in general that is not Zoom or computer efficient by now, what would be some of your recommendations for them aside from, you know, quitting life at this point?
Well, it's an interesting question. First issue with regard to attorneys and judges. I refer you to the Rules of Professional Conduct 1.1 competence, and in particular, the official comments. And the last paragraph says maintaining competence. And it says to maintain the requisite knowledge and skill, a lawyer should engage in continuing study and education, including the knowledge and skills regarding existing and developing technology that are reasonably necessary to provide competent representation for the client in a particular matter. From my perspective, and I think our committee's perspective, is that lawyers need to know how to use Zoom or the digital interactive platforms. That would be, you know, Microsoft meetings, Google, whatever, all the different things out there. And that's true for judges as well. There are some judges, I don't think it's certainly not the majority, it's a small percentage, do not like to use Zoom, and we've heard some judges are not having any hearings. They're deciding all cases or all motions by pleadings. And that varies in different courts throughout. So we're going to press that folks need to understand how to use this technology, and the courts need to use this technology. Second, we're looking at whether or not this gets passed or accepted, is to have minimum hardware requirements to be able to use Zoom. Judge Groner has a headset on. Headsets are excellent. When I've had trials, bench trials, I've asked most people to use a headset because it's more clear. The audio's clear. People will look away from a laptop, and depending on how strong their microphone is, when they look away, their audio drops. It just makes clear. If you look down in Texas, and some of the judges that are there, you think they're on a radio station, the way they have everything set up. So we're looking at what's the minimum requirement and whether or not people can get on to either depositions or motions by using a phone. Sometimes phones are aggravating. People are walking around with their phone, or they put the phone on the table and you've got a picture of a ceiling, and I typically will tell people to set the phone so they can hear, see themselves, or use an iPad. But those are the types of things we're asking, is that because if you have clients who can't get on or their connection is not good, that's very frustrating, and it's frustrating for everyone. So there should be a minimum requirement to get on. And if you can't get on, then you can't use Zoom. You can't say, I'm going to have a deposition or I'm going to have a hearing before Judge Groner, because that's going to waste the court's time if we're trying to sit around and get people connected. That's a general response to that. Judge Groner?
I agree with you 100%, Judge Ackert. You know, I've been doing motion call on Zoom for, like I said, almost 9 months, and even to this day, I'm so surprised, to say the least, that lawyers have not figured out Zoom. Judge, I'm having trouble. Judge, you know, I mean, I have lawyers, you know, doing motion call from their cars while they're driving. Are you kidding me? Y- y- I mean, I understand people have commitments, but adjourn the motion. You know, don't make a mockery of this. I mean, I have lawyers coming on with, you know, that aren't dressed appropriately, and I have a, you know, and that's another issue is, you know, how do you dress for Zoom, right? I mean, my feeling is if we're on the record, we're in court, and if we're in court, you see, I have a virtual background, I wear a tie, I have a robe on. You know, this is real. These are real cases with real orders and real consequences. So let's treat it like a courtroom. And you'd be surprised, there are lawyers out there, not a lot, that, you know, come on without a tie on, without, you know, have a t-shirt. Oh, Judge, I'm sorry. Next time I'll wear a tie. I said, no, not next time. Right now, go get a tie. Be respectful. And I think that it's not the clear majority of the lawyers are trying their hardest, but it's, you know, it's always the devil's in the details. And there's so much I want to say about Zoom and decorum and, you know, procedure, but I think that someone like you, Judge Ackert, you've been studying this Zoom and how we can make things better for the lawyers and how they can make it better for us. But the real problem is we're all out there trying to do it and no one really knows. There's no uniformity. So it's, to me, it's a very difficult process for the lawyers because they don't know how each court operates. And I tell lawyers all the time, like for instance, let's just stay with the jury trial issue. People come to me all the time, settlement conference, hey Judge, when are we gonna be able to do trials? And I always say, when Uncle Tony Fauci says I can do trials, I'm gonna do trials because, you know, I am in a bubble and I'm real careful. And as far as I'm concerned, civil trials are not a priority right now to put people's lives at risk. I think my chief judge agrees. The numbers are way too high. But when it comes down to it, even if the courts are vaccinated and the court staff's vaccinated, maybe some lawyers are vaccinated, how are we going to get a jury panel of, you know, a representation of the whole community? We all know that there are issues out there, people not taking the vaccine, people are afraid to take the vaccine, people that can't get the vaccine so fast, people who live in bubbles, people who take care of elderly or sick. So it's a complicated process. And to judges that are, and there is a question out here, and I'm going to get into it, there are judges out there, and I know this, that are setting trial dates, January, February. And we all know that from what we watch in the news, these are going to be the worst months, the worst COVID deaths, the worst amount of cases. So no trials are going to go in January or February, and no court can force a lawyer or a litigant to come to a courtroom and to try a case because that judge wants to try the case. That's just not going to happen. And maybe I'm speaking for myself, but I just don't think that's fair to everybody involved. We have to work together in this situation. We are all in this together. And kudos to the committee, Judge Ackert, because I do talk to Judge Fazard. She tells us at meetings what's going on. And I know how hard you're working, but it's a moving target. And we just can't, you know, other than the criminal division, which that poses some serious issues. What do you do with people that are sitting in jail and they can't get a speedy trial? They're not getting released. We know that. We haven't come to that. But, you know, that's the heart of how we live in America is due process. And those people are not getting due process. It's not anyone's fault, but it's a big problem. So in my opinion, if trials are going to go and they have to go first, let's empty the jails and get those people tried before civil division goes. That's my opinion. And so I might have gone off on a tangent, but that's not the first time or the last. But I do agree with everything you said, Judge Ackert, and I really do believe that we all have to try our hardest. But I will tell you this: there is a problem with certain, like today I had a default judgment, and the person, the client, they couldn't reach, and they finally get them. They couldn't get on a screen, so that the lawyer said, Judge, I can get them on a phone and put it up to the, so you can hear them and I recognize their voice, and can we just take the default that way? And I was reluctant, but I said, okay. So I said, raise your right hand. I can't even see them. Raise your right hand. Do you solemnly swear? Right? I give them the oath. They take their testimony. We have a default. Now, it may come back and bite me, but it was the best I could do. They have no way of getting on Zoom. And, you know, those are the issues that can come up. But among the lawyers, Judge Ackert, I totally agree with you. You need to master this. This is here to stay. And if you master it, it'll go a lot smoother. But again, devil in the detail. Every court is different. Every court's needs are different. And I tell the lawyers, you know, go to the law clerks, email them, say, what do you need from me? I didn't see it in your protocol. What can I do to make sure this motion's being heard? You know, is the judge, you know, does he take the bench at 8:30? What if I have another hearing? Communicate with the court. We'll work with you, but don't just, you know, come on and say, oh, I gotta go. I have a deposition, so I can't stay for my settlement conference. No, it doesn't work like that. You know, we are having enough trouble with Zoom to try to help the lawyers, but help us too. So anyway, I just thought I would sort of throw that out there.
I agree with Judge Groner on the issue of due process and the criminal trials. I think across the state, the courts are looking at when we can start doing more trials. We're going to put criminal trials first. We just have to. There are a number of issues, and everyone knows what those issues are, that this is troubling. And civil jury trials, when that will start, it's anyone's guess. And we're all trying to figure out where this pandemic is going and where we'll be. I'm fairly certain that everyone was like me back in March, that we weren't thinking on January 8th that we'd still be in the midst of this and wondering where we're going. So we're here, but we're trying the best. And I believe most lawyers are trying to do well, clients are trying to do well and work with the courts. I will take off on this issue that Judge Groner raised, uniformity in the courts. This is one of the things. I've been on the bench since 2015. I have kind of a split docket. Half my docket is the family division, half is the specialized business docket. And it surprises me that through, and I worked with business organizations throughout the state, throughout the Midwest, when I was practicing. And I am surprised by how our court system is not uniform. We have separate funding sources for every county. We have separate rules, and this has pointed to more of the difficulties of the lack of uniformity, the lack of consistency, not only from county to county, but within each county. Judges may decide to do things different than other judges. And I find this interesting. So when Bridget McCormick, Chief Justice McCormick, is speaking, and she has in the last week or so, and there have been articles on this, about trying to get all of our data and all of our resources under one roof. And she's broaching the subject of whether or not we have one funding source for all of our courts. Can we get there? How do we get there? That's a big ask. But that's important to you as lawyers. And how the system works and how can we be better at this system. So I'm asking you to pay attention to that. Learn what we're talking about. That is extremely important. To say we're going to be uniform across the board is difficult to say. Wayne County is a state in and of itself, and how Wayne County works as opposed to Antrim County, there's differences, but how we approach the procedure and what we're doing should be similar. And you should be able to go to each court and find information regarding what the courts are doing on particular hearings. So the question was asked whether or not there's a resource that you can look to see if a court has met guidelines to reopen and so on and so forth. Every court should be posting on their websites their rules for each division, where they stand in terms of the phases. I think almost everyone's at either phase 2 or phase 1 right now, but and if they're not posting, I would encourage you to contact the court administrator and say, are you going to post on the website? That's what they should be doing. And we even have to look at Kent County, and we hadn't posted for a while, so we try to update where we are. And we're looking at that issue of people didn't know who to contact within a judge's chamber. Who should I be contacting to set a hearing or talk about these trial dates, or are there going to be adjournments? How are you going to do this? So we're trying to get up to speed, and I think over the 9 months, everyone's been doing fairly well to identify what your procedures are. Motion days, I think, Judge Groner, are you doing specified times for each motion, or are you breaking them down into time slots?
No, I've always been an 8:30 judge. 8:30 I get on, and I'll just tell everyone how we do it, because I watched other judges come on at 8:30, actually a little earlier, bring the lawyers in, and then my court clerk will tell everyone there's going to be a chat, and the chat says, when you and opposing counsel are ready, let me know. And so when she has about 3 or 4 ready, I turn on the recording, I turn on the YouTube, we go live. And while I'm doing the cases, they're chatting with her. And so she keeps calling cases, and I never have to go off the YouTube. It's remarkable, as opposed to, and that was one of the, in my opinion, the good things of Zoom, because in the past, you got motion day, people lining up in your courtroom, all kinds of, they're walking in, they're walking out. There's commotion, they're writing down, I'm going to this courtroom, I'm going to that courtroom. There's a chalkboard. It was total chaos. Now you're in Zoom, and yeah, you might have other judges to go to, but all you have to do is put in your chat, I'm going to Judge Hopke or Judge Allen or Judge Fazard. I'll be back. Here's my cell number. Great. And my clerk has that information, and we'll work with the lawyers, and it works real smooth. My motion call goes quicker than it did before, because of that reason. And the other reason is, and this is, I'm going off in a tangent, is, and I've talked to John and Mike about this, I have found that during Zoom hearings, the lawyers are actually nicer to each other and nicer to the court. It's like we all realize when it comes down to it, the common denominator, we are in a pandemic. That's why we're on Zoom. And so when I come out in the morning for my settlement conferences and my motion, I always say to everybody, how's everybody doing? You guys okay? Because we're all in this business together. We just have different jobs to do. And the lawyers in Wayne County know me, and many of them are out there. I can't see you, but those who practice my court know how I feel. And I'm sure Judge Ackert, you feel the same way. This, we have to get through this. This is a very, very difficult time, but once we get through it, Zoom's going to stay with us. And so therefore we have to get efficient at it. And 90+% of the lawyers I've talked to love Zoom for obvious reasons. They can be in Judge Ackert's court in the morning and be in my court in the morning. We couldn't do that.
Yeah, the court around the, are you? Well,
again.
Okay. Go ahead.
Please, go ahead. No, please go ahead, Mr. Judge Ackert. Judge Ackert. Doesn't-
You may have froze for a second there, so I thought you had stopped.
Go ahead, please.
So there is a good reason not to wear a headset. No. So there's different, that works well, using the chat and coordinating. Some judges put everybody out there and they're all on, and it can be chaotic. I use a slot system, so I'll do so many at 8:30, so many at 9:45, or we'll do 9:30 and then so many at 11. But we're coordinating with everyone in there so they know where to go. Some judges are doing specific time slots, and I think that what we're hearing, and I'd like to hear from the lawyers too, what are you preferring from the courts? What Judge Groner's doing is there's a lot of communication going on, so at least you know where you are, and if you can get to other courts without being concerned that you're leaving and all of a sudden you're going to be left out in cyberspace. So that works. Some judges don't do any of that. They're just going to call the case as it's there, and there's a lot of difficulty. So we'd like to hear from you. You can put it into the chat here.
I just saw a question. It's not on there. Maybe it just came to me individually. I won't say who it's from, but it's from a lawyer he says this, one of the old lawyers. He had to produce a letter from his primary care physician as to why he didn't have to go to court. Now that is absolutely not necessary. And I'm sorry to hear that. And I've had lawyers say to me, Judge, I've been ordered to go to court. I'm afraid. I don't want to go to court for anything. What do I do? And my answer is, you tell the judge, you're in a bubble, you're taking care of your mother, you have pre-existing conditions, whatever you want to tell them, say, I'm afraid of COVID, I'm not coming to court. And if they give you a hard time, call the court administrator. I guarantee you, Tom Boyd will say, what's that judge's name? I'll give him a call, or I'll give her a call. Because there was a memo sent months ago. Judge Ackert, I'm sure you got it, from Tom Boyd. He's the state court administrator, who said the following. Do not, if you insist on handling, I don't know what the right word was, I wouldn't say mundane matters, but non-trial matters. He didn't say it like that, but your routine matters. If you insist on having people come to your courthouse, courtroom, and they don't want to come, you better have a good reason, because this will be reviewed by an appellate panel, whatever that means, meaning don't do it. Don't do it. And it didn't mention trials, but I would assume trials are part of that too. And Judge Ackert, you probably can speak to that memo, or maybe what you've heard, but I tell the lawyers, they said, well, yeah, but this judge, they said I have to come. I don't care what they said. That's the memo I got, and I'm going to live with it. And I think it's the right memo. So, and again, it goes to the broader perspective of SCAO, and specifically Chief Justice McCormick, who says we have to embrace Zoom. This is very important for the future of what we do, and really for the future of how the world is going to function. It's not just the courts. This is the way of the future. Let's work with it. And so, Judge Ackert, if you want to speak to that memo, or to really my advice to these lawyers, hopefully I'm right, but I think it's obscene that a lawyer has to bring a note from a doctor to say he's got pre-existing. Are you kidding me? That's terrible.
Well, that's the last time I did ask that.
Well, sorry if you.
That's absolutely true. We need to work with everybody. I don't know whether or not you have a pre-existing condition or not. If you say you do, I'm assuming you do, and we've been told to make that assumption. But we're all in this together, and so and I agree. If you're having difficulty, call that county court administrator. See what they have to say. If you don't get an answer, call Tom Boyd. You'll get an answer. There is no doubt. I agree with Judge Groner on that, and the able to do a lot of court work on Zoom. I had an 11-day minority shareholder oppression trial, bench trial. 11 witnesses, 270 exhibits. We handled it all on Zoom. There are a lot of logistics we walked through beforehand, so we knew what the exhibits were. We had, eliminate motions and all of that. It worked out well. I would say the most difficult part for me, and I've tried divorce cases, tried custody cases, been trying all along evidentiary hearings. I find the most difficult part of Zoom is cross-examination. That you get in a pace, you get around that issue that you want to score on, and you start moving more quickly. In the courtroom, a good lawyer knows how to control the witness and stop them. You're not really talking over each other. Much harder to do in Zoom, and all of a sudden I find myself having to stop the examination and say, you're talking over each other. And I hate doing it, but we've got to also keep the record. Most of the attorneys get the feel and they'll find their way, but I find that one of the most difficult aspects of the Zoom hearings. We will have, so I have neglect cases, abuse and neglect cases. Termination of parental rights need to be in person if the parents are going to be there. That's a bench trial. If we get to that point where we're having, I don't know if any of you are handling any neglect cases, we've done a few in-person terminations, but we can socially distance everybody. And we've got the courtroom set up so everyone's safe. And oftentimes parents aren't showing up by that point, but we will make that available. And there are some other hearings that are going on that are available. I think, Mike, you had told me that one interesting development is that on landlord-tenant cases, there's more tenants showing up for the hearings than they were when they were in person. That it's easier for them, or they feel less intimidated to come on Zoom. And that's a good thing because you can work out compromise and not have issues. So that's beneficial. On just another side note on Zoom, we have found that kids do much better on Zoom than in court. So issues regarding reasonable preference in family cases, or issues regarding the kids in the neglect cases or in guardianship cases, they are much more forthright. They speak easily. We get more information from them. It's because, one, they're comfortable with Zoom. They're comfortable with video technology. And so I'm always trying to see if we can't get a game to play on the Zoom, but it doesn't seem to work. But
yeah, let me get Jolet in here for a second, Judge, because there's a question I think Jolet would be pretty capable of answering. So Jolet, as an attorney who represents a lot of insurance companies, what are you seeing, positive, negative, about Zoom, and also some challenges with getting the client to get familiar with Zoom or remote type proceedings?
Yeah, that's a great segue. And I think that what we're hearing from the judges is very powerful with respects to what is happening currently, how we're able to handle it, and some of those types of pros and cons. Where I think I would like to just spend the next couple minutes is kind of talking about, from a defense attorney's perspective, what should we expect going forward? And I think it's an important topic. And I think the title of the presentation, being Zoom into the Future, is so important, because whether you're a small firm a large firm, whether you're an associate or a managing partner, there are so many moving components, not just in the practice of law, but actually the management of the business, expectations of how many associates may be needed, how many partners may be needed, looking out for the best interests of your clients from a monetary standpoint, from the fact of fees and expenses and things like that, to your personal life. There is so many moving components to what has happened over the last 9 months, specifically what's happened in the past. And just to give the judges here, because I think in the end, I'm going to end up turning to you guys. But just thinking, are we ever, I can tell you that pretty much every attorney on the line right now is probably wondering, are we ever going to walk into Judge Groner's courtroom again on a Friday morning, or any of the Wayne County judges, or Oakland or Macomb on a Monday or Wednesday, or any of the other courtrooms across the state during motion call, and see a packed courtroom? Am I ever going to advise my client that that I was, in court at 8:30 as scheduled and didn't get out of there till 12:30? When I'm trying to find coverage for a motion in Oakland County that starts at 10, because I have a motion in Wayne County at 8:30. I can tell you pre-COVID Zoom time period, the answers were easy. If I had a 10 o'clock motion and I had to be in Wayne County at 8:30 and 10 o'clock someplace else, I had to find coverage. Also, let's not underestimate that when you're in Wayne County with 4, 5, 6, 10 floors of courts and lines and things like that, you may have sent down an associate, 2, 3, some firms 5 or 10. Now one attorney may be able to sit at his desk and knock a few of these out. These are some of the questions regarding motions, and I'm not even getting into settlement conferences and things like that. But I can also probably speak for a majority of the attendees and to the attorneys across the state, in meaning that, just sitting here without any other discussion, I could tell you that I'm probably more for a hybrid, right? I think some motions are absolutely Zoom appropriate. And I don't mean to pigeonhole a particular type of motion, like a motion to compel, or a motion to extend dates from track 1 to track 2, because maybe a judge won't allow a stipulated order. Certain types of motions, discovery related, might be, I think appropriate for Zoom. However, a complicated motion for summary disposition, or something where it may take longer than just 5 minutes on the record, may be more appropriate with a face-to-face, or where exhibits could be easily handed back and forth, and things such of that nature. So that's one area that I would really like to touch on before we conclude today, which is the future of motion call on Zoom. And I understand that Judge Ackert, who's part of the Lessons Learned Committee, and obviously Judge Groner, who is probably participating in a lot of discussions in Wayne County, that's some of the direction, I'm going to be honest with you, that I think myself and most of us are curious as to what do we have to look forward to? Now, I'm probably going to go a little out of bounds here, and maybe it's not appropriate for this area, but let's just be honest. Zoom has affected the personal lives, the family lives, the daycare, the schools, everything. People are not in equal situations, right? Some attorneys may be part of where both spouse may be working, where or their kids are in school in person or virtual. Everybody is in a different situation. So I don't mean to speak for every single person, because we're all in certain circumstances, but I can just tell you this. If in December of 2019, if my wife asked me if I could grab my kid from basketball, because he doesn't have school today at noon, and I was going to be in a settlement conference in front of, Judge Groner in the morning, I would likely not know the situation and not commit myself. However, under the current situations and with Zoom, I think it has played a big part in the calendaring of not just business, but also personal and family and other types of activities. Zoom has played a large role in being able to accurately predict, or at least better predict, where you were going to be at what particular time. Everybody knows, all of us that have practiced on the civil docket, realize that when you commit, whether it's a motion to adjourn dates or a motion for summary disposition in Wayne County at 8:30, 9 o'clock, 9:30, you likely will not make another plan till at least 2 o'clock that day. And sometimes that's not enough. So where I'm looking to gain any type of input I can, and maybe today's not the day, right? Maybe today's the time to get your guys' ear or anybody else who could listen to us. What does that look like? Is it a hybrid situation? One other area, not to pile on, settlement conferences. I've heard things from plaintiff counsel. I really have. I've heard it before. You know what? We settle more cases if you demand that the adjuster fly in from out of state or drive in from an hour and a half away, fight traffic, find a $20 an hour parking spot, walk up the stairs because the elevator might not work, and you can put some pressure on them face to face, Judge. I've heard that. And I've heard that, there might be frustration on the other side. I can't help but disagree. And I want to know, if possible, from the judges, if they agree or disagree with mine, other side, or maybe somewhere in between. But I don't know an adjuster, an insurance adjuster, and that's what I do. I don't know a business owner or client, and I certainly don't know an attorney that would ever utilize a in-person versus virtual to either not settle a case that has value, not pay claims that are warranted, not resolve a case simply because the adjuster doesn't necessarily have to come in person. I actually have a different opinion that if indeed somebody with the authority, with that type of knowledge, they pay the claims or pay the lawsuits based on merit, not on whether they have to come to court. Certainly, I would assume that they might be more irritated if they had to, or more upset with the situation if they could do something simply by a phone call or a Zoom or being available, but yet rather had to board a plane, get in a car, drive, waste an entire morning when, let's face it, a settlement conference goes both ways. So these are kind of the practical areas. And I know I'm just touching on a couple, right? I'm trying to avoid things that are outside of the judicial system, such as facilitations and things like that. So those are the two areas that I'll stop talking and reflect on right after I finalize my final thought, which is, do we believe that the future going forward of these virtual hearings, that we will see, and Judge Ackert, this might be better for you, that we will see some sort of update in court rules? Will there be some sort of Zoom portion of court rules? And I can tell you one of the concerns that I have, and once again, I hate to speak on behalf of the entire audience, or at least the defense counsel, is taking deposition testimony of an opposing party, trial testimony specifically, but just deposition testimony of an opposing party when all you can see is a 2-inch by 2-inch box just around me. I'm sure everybody out there is likely realizes I'm the only one in this room, and I would assume the same is for the rest of the panel. But when you're taking the deposition of a plaintiff and their eyes may go down or to the side or over here, what is our protection in securing? And I don't mean to just pigeonhole the plaintiffs, but those are usually the people that I'm attempting to take their deposition or testimony. But it would also go for a defendant, I guess. Although most defendants, if not all the ones I know, are completely honest and would absolutely tell us who exactly are in the rooms. But is there some sort of concern amongst the judiciary, or at least talks in the areas that you guys are discussing, which would cause some concern to in any way violate the sanctity of depositions and testimony under oath, to protect, if we are going to be able to, or be forced in the future of doing some of these activities, to protect the integrity of a deposition? So I'm going to pass that on, John. I'll let you kind of direct to the judges. But before I move that on, I want to touch on one question that was kind of asked, and I don't know if it was direct, but it was briefly mentioned as to the clients that are out there that might not be sophisticated enough or might not have the equipment available to perform Zoom functions or any virtual functions to the capabilities that are required by court. And what I mean by that is whether it's an insurance adjuster or whether it's a plaintiff from their couch, to be able to, I don't know, require them to have Wi-Fi that is fast enough, a device that is updated enough or that has enough room or capability to be fair. Because let's be honest, if one of the panelists, and none of you have been, but if one of us were very difficult to hear, muffled, broke up a lot, as an audience, it's difficult to watch. It's difficult to understand. It does put you at a disadvantage. And I hate to say the loudest person in the room is often the most heard, but I'm not going to lie to you. You brought up a great point, Judge Ackert, that Judge Groner's wearing that headset, and he sounds great. He has the capabilities to have a technological advantage that not everybody has. And I'm not saying that's necessarily the intent, but these are some of the practical concerns I've known. I've thrown a lot of them out there. John, I leave it to you to kind of ignore anything you think that I said that might not be interesting enough to delve into, but I would love to hear what these two judges have to think about some of these practical situations that I've mentioned.
Sure, yeah, no, Mike, you're always coherent and well organized. So I got it all written down. Yeah, so I'll kind of parse that out for the judges. One of the things I got to touch on quick, because Mike and I both know this case. I believe it was with his office. We did have a judge who was not happy about a case not settling, and they ordered the adjuster to fly in from Texas in November. Obviously, it was against multiple objections. There was no time to file an interlocutory appeal. And I guess with some people, I've got multiple questions about that specifically. What everybody wants to know, Judge Ackert and Judge Groner, obviously you wouldn't do that, but for us that are litigating cases, and it's usually the adjuster that gets ordered to come in while the plaintiff gets to hang out in Florida, who do we go to? Or what, do we go to SCAO? Do we go to the court administrator's office? Do we go to the chief judge? Who do we go to when there is a single judge or a couple of judges who are using in-person appearances to force settlements? Or even, for example, I got another question from a gentleman who had a trial date 1/5/21. About a week ago, the court adjourned it to 1/27/21. So who can we go to for some guidance on how to handle situations like this? And most of the judges, and certainly from my experience, have been overwhelmingly supportive of whatever the parties want to do. You guys want to adjourn trial? Fine. You guys want to reopen discovery? Fine. You want to go to facilitation? Fine. There's only a select few judges that seem to be using this to their advantage to try to force settlement. So who can we go to? Who can we talk to about the very few problem situations that we're seeing?
I defer to Judge Ackert.
Yeah. No, I'm deferring to you. Let me first talk about the future, and then Judge Groner will touch on these topics too. I agree with what Judge Groner said. Zoom is here to stay. If we think we're going to envision the court not using or not having as an available tool Zoom, that's just idiotic. It is cutting our nose off in spite of our face. How it will be used and the process of its use is still being worked out, and that's going to work through. And there will be the Michigan Judges Associations, the Probate Judges Associations, the prosecutors, the defenders, the sheriffs, everyone's going to be involved. MDTC, ABOTA, all of these folks are going to have input on this. We will be making recommendations to the Supreme Court, and then they will determine where they want to go with this. there are judges, I can tell you, there are judges who think we should never have Zoom once we're done with the pandemic. And that's a small minority, but that's just how some are thinking. There are some judges who think we should never have to have people come into the court again. And that's not realistic. How do we go forward? The reality is our work in trials and the like require us to come together. There are reasons why we should come together, but we can utilize Zoom to enhance access, facilitate easy scheduling. For example, setting a trial and you're trying to get experts there. When you can have an expert appear by Zoom, that's much easier to schedule the expert, bring it in. We can take experts out of order. People coming, witnesses coming from a long distance. Those are the types of things we can utilize Zoom to make us far more flexible, and that maintains the trial schedule as well. How many times have you been in a situation where I literally can't get the expert here for all these good reasons, and okay, I'm going to have to adjourn this trial, and then trying to find another trial date, or splitting up the trial date. I think Zoom can be very beneficial, but we will come back and having in-person motions. There are some motions that I think that easily can be handled by Zoom and no one has to come. There are some summary disposition motions that people want to be in the court and there wants to be an engagement back and forth. But we can all kind of come to an agreement. If all the attorneys tell me we don't need that, we can do this by Zoom, I'm going to defer to the attorneys. Unless I say, I think, hey, we need to go forward. And that gets to the issue of who do you go to talk about a judge who orders someone to fly in from Texas? That's a difficult one because that's where the independence of the judge is separate from the administration of the justice and how we're handling the court within a county. So the judge has a right to say, I'm going to issue this order.
Can I just say one thing,
Yep.
Judge Ackert? I agree with you on that last point. Post vaccination, any judge who orders someone to get on a plane now, no way. That's SCAO.
Yeah.
SCAO has made it clear. Now, post-COVID, post-vaccination, I agree with you. Judges can, that has nothing to do with SCAO. I think I'm trying to focus, and I think you agree with me. Let me just say a couple things because we're running out of time, and I didn't mean to cut you off, but
No, it's fine.
Mike spoke, and it was like the Gettysburg Address, but it was he covered a lot of topics. And let me just start by saying, and this is something I've told the lawyers, we all, as lawyers, as judges, we love the human interaction. We took it all for granted. I took 2 weeks off end of December. I was miserable. Ask my wife. She goes going crazy from me. I hated it. I didn't see anybody. That's one of the reasons I love Zoom. It's therapeutic for me and the lawyers. We talk more about things other than the law at settlement conference than the law, because I want to make sure everyone understands the big picture. Now, getting back to the hybrid, Mike. Yeah, and again, it goes to what Judge Ackert said. It's a moving target. We don't know post vaccination. We don't know post, COVID sort of where we get it under control. What are going to be the parameters? How much independence are we going to have from certain rules the Supreme Court's going to lay out? Are they going to still insist that we, prefer the Zoom and that we don't force lawyers to come to court for, non-trials? I mean, I don't know where it's going to go. I don't know that SCAO has decided where we go on that. But I think that a hybrid, again, going back to the interaction, I miss seeing the lawyers. I miss being in chambers with the lawyers, with my staff. I haven't been to the courthouse since March. I haven't been to the courthouse. my court clerk goes every day. That's just the way it is. She's under the tutelage of the county clerk, and she has to go. So the clerks are there, and we work together, but I miss the lawyers. And hopefully they miss me and some other judges. But so it's not only do I think it's important to come to court for certain things, but to come to court for a motion call, Mike, I don't know what I'm going to do. My wife says, you're going to go to court. You love motion call. You love having those lawyers in your court. You're not going to want to do it on Zoom. I don't know. I don't know what I'm going to do, but I probably will go to court. But again, Mike, that again forces you to put a lawyer there, and that lawyer can't be in Macomb County that day for a settlement conference because it's a Friday and it's, they don't, but on Monday they could be in Macomb, and then they can't be, if that judge forces them to come, they can't be in Groner's or Allen's or Ackert's for a settlement. So it goes both ways. But I think we all have to be respectful of each other's, professions. And so I understand that, plaintiffs have a different perspective than defense. The plaintiff's bar loves Zoom. The defense bar, most of the lawyers really like the Zoom. But again, it's different because plaintiffs aren't billing, defense are billing for their hours, their hard working hours, and plaintiffs aren't. So it's a fine line. And the last thing I want to say is, as far as bringing the adjusters in post-COVID, look at it. Mike, I hear you, but if a judge feels that a case should settle and they feel that a plaintiff's being unreasonable, a good judge is going to go to that plaintiff and say, you're being unreasonable. And I've had plaintiffs say, Judge, I got to tell you, it's not me, it's my client. I worked it out with the defense lawyer. Would you mind talking to my client? No problem. Bring them in. And the same with the flip side. Defense lawyer says, Judge, my client, it's my client. I can't tell them that they should pay more, but they should. But don't tell them I told you, but can you bring them in and tell them? You be the bad guy. Sure. So I'm going to order that person to come in from Texas because you're going to say to me, Judge, get that adjuster here from Texas, because they're not listening to me. I mean, you wouldn't say it because they always listen to you, Mike, but it goes both ways. So I hear you when you say it's not fair a lot of times, but as judges, we have an obligation to settle cases, no matter what division we're in. Judge Ackert, he's the same way. Whatever he's doing business docket. His cases are much more complex. And so if we have an opinion on something and we decide that we're going to force someone to come in for settlement conference and they're going to stay there all day until we get it done, that's their right. And so I hear you. And as far as where we go from here, again, a hybrid, it may work. Work with your judges. We don't have a policy. I don't know what Kent County's doing yet. We haven't had judges meetings where we've discussed what's going to be our policy, folks. How are we going to do motion call with everybody having Zoom motion call? Right now, we don't have that. A lot of the judges, like Judge Ackert said, are just deciding cases on pleading. So I know I'm going every which way, but I was trying to follow what you were asking, Mike, and I hope I've covered some. I know we're running out of time.
I appreciate that, Judge. Actually, I really appreciate it because that's kind of what I was hoping, that we could get some sort of and I don't want to say a commitment because everybody knows today's different than tomorrow. And I know that, it's very easy to say this is the game plan now, but this is the game plan going forward. But there are, obviously business, I guess, implications to how many attorneys does it take to send a Friday motion call pre-pandemic versus post-pandemic. And when you don't have any notice of what it's going to be like later, a lot of firms, a lot of attorneys, and a lot of associates might get a little bit nervous, a little bit anxious as to what's needed. And are they going to be caught shorthanded, overstaffed? So that I love the answers you gave, and I really do appreciate that.
And remember one thing, that after COVID, after the vaccinations, after we can safely go back to the courthouse, what's going to happen if I want to do Zoom on Fridays, but the judge next to me wants to go live? What are you going to take your phone out and say, sorry, Judge, sorry, Judge Hughes, I gotta do a Zoom call right now for my motion with Judge Groner. It ain't gonna happen. So that poses other issues, but we're not talking about, the judges have a lot of issues from our end.
Yep.
So we have not talked about that issue. So, you know, that's another big problem. And again, it's the hybrid doesn't work for motion call.
Yeah, one more question, then I think we can ask the audience to pipe up if they've got anything new. But one question for you two judges, if you don't mind. One of the concerns I have is there's this moving scale with jury trials. All of us, and I think this has come up, all of us are concerned because there's 55 jury trials up in this court on Friday morning. I don't even think, you know, my most skilled mathematician could come up with which case is older versus not older, trying to figure out all these other things. And then obviously we get these trial dates that some people are referring to as fake trial dates. And a fake trial date, just so Your Honor would understand what I'm referring to, is a trial date that a judge is setting, even though they know with 100% certainty it can't go because of whatever rules. Should us defense counsel or plaintiff counsel, I guess for that matter, but should us defense counsel be worried about a judge saying, I'm moving your trial to June, and then all of a sudden the numbers switch and have that judge say, never mind, it's April. The ultimate fear is there a possibility, and is it allowed in each court, is there going to be rules that when a trial is moved, that we can at least be certain that it will not be moved up? Or am I just way out of bounds here, Judge?
I'm going to let Judge Ackert answer this. I'm going to give you my first disclaimer, which is I have set no trial dates during COVID. That's the easiest way. Okay. Now, with that being said, I'm going to let Judge Ackert answer the question. Fair enough, Judge Ackert? Since you're the junior judge here, so.
That's right. I don't know that there's an answer to that. And we haven't, that's an interesting question. I've never even thought of a judge moving it up. Hey, I can move this trial date up. That, I just look at it from my perspective, being I litigated cases as well as doing transactional work. I don't want to have someone call me up and say, oh, in a month, you got to be ready to go. That's a whole, when you were thinking, I've got 4 months, that just doesn't.
Yeah, pre-pandemic.
That doesn't make sense to me, but I can't say that. Now, once again, once we're out of COVID, if a judge wants to do that, that's the judge's docket. That judge can do whatever they want to do. And that's where this independence is different from the uniformity. But I want to answer one question on Michael O'Malley. The same question is, if a judge orders a client to travel against personal health reasons or corporate travel guidelines, I think that's, again, a call to the court administrator. Because again, it was very clear that under COVID, we're not going to force people to do something that puts them at risk. And we shouldn't, because we're the court. We shouldn't be seen as acting against the governor or acting against the Department of Health and Human Services recommendations. But we should be in compliance.
You know, one thing.
Let me just say one thing. Settlement conferences, status conferences. I'm using Zoom a lot on status conferences. Hey, you've got an issue, you want to talk to me? Get a hold of my clerk, and we'll find in the morning, we'll find at night, we'll find noontime, wherever I've got a time. We want to sit for 15 minutes and talk on Zoom. I find that very helpful. And then you don't have to come in. You're looking at each other, you're seeing, and we're getting a lot of things done. I think Zoom can have settlement conferences on Zoom, not having to bring everybody in. Clients can stay in their offices. They can, but as long as they're committed, and we're going to be talking, I think settlement conferences can work very well. I've been using breakout rooms, going back and forth. I actually find it more efficient when you're in the court. We're sometimes BSing a lot, and then I'm caught in between, this goes much more quickly. Mediations, same thing. I think we can do on Zoom. So we're gonna be sorting through this, but COVID is still, hovering over us.
Can I just piggyback on what Judge Ackert said? A lot of judges are not doing settlement conferences, and that's their prerogative. They're basically saying, if you want to engage in meaningful discussions, we'll give you a date. But if not, you want to go facilitate, go ahead, here's your next date. And that's fine. I don't do that. I have settlement conferences for a couple of reasons. One is the therapeutic. One is the kumbaya moments. How are you guys doing? I miss you. Miss you guys. How are you doing? Okay, great. Right. But then we get to the case. And what's a little frustrating to me is a lot of times I get to the case and they're like, oh, well, I'm just standing in, Judge, and my adjuster, I don't, well, why don't we talk settlement, guys? You know me. I've been on the bench now in civil for 6 years. I'm trying to help settle. Be prepared. Just be prepared. And if you don't want to come on settlement conference and you say, you email my lawyer and say, you know what, love to see Judge Groner, but we're not going to get anything done today. We got to do more discovery. Fine, you don't have to come in. But I assume if you're coming in, just assume I'm going to say to you, what can I do to help you settle it? And, I'm not having a lot of luck settling cases, but I've had some good luck. And like Judge Ackert said, when you engage with the lawyers and they want to try to settle with you and you put those breakout rooms going, it's fabulous. It's great. And we're getting some done. But, for the most part, to the lawyers, don't waste our time. We'll try not to waste your time, but let's try to work together. And if you have, after the seminar, if you have thoughts that didn't come up or you didn't want to ask a question, email me, email Judge Ackert, or email some of the judges that are willing to discuss things and take a little criticism. You know me. You can say whatever you want about me. I don't care. If I'm doing something wrong, let me know. And that'll help us get through, because again, devil's in the details. It's so hard to figure out how to move forward here. But I think this is a very good panel discussion. We open up some good ideas, but things are going to come up after this. And I don't know if it was said earlier, but this has been recorded, and a lot of lawyers who wanted to be here couldn't. And so I think, John, it is recorded, Mike. And so I think if someone wants to see it, they can contact MDTC, right, if they want to get a copy of this.
Yep, that's correct.
Yeah, I just concur with Judge Groner. We're from the government. We're here to help. So
A special guest here, man. That's my man Chai. He's here. Yeah. And again, I bring him up here only because we have babies coming on. We have cats, dogs, people screaming, and the lawyers, Judge, I'm so sorry. I say, no, it's okay, counsel. It's okay. I understand that you got little kids. I understand. It's okay. It's soon. We have to be considerate of what's going on, right? We have to accept certain things. And so anyway, I just thought
you just reminded me of people showing up, and I wanted to touch on the issue of depositions. This is something we're talking within our committee. We've had some judges talking about this. Remember what we said at the beginning. When we're on Zoom, we're in court. So when you have depositions going, you have a right to say, I want, if the attorney and the client are in the same office, I want to have both of those folks on camera, because we don't have a court reporter there to be able to check to see, make sure the attorney isn't talking to the client, showing notes, all those types of things. The things that you would see if you were at a deposition. It's the same thing. When I have trials, I will stop in the middle of witnesses when there's a short break between questions, and every now and again just say, take your laptop, take your iPad, show me the room, make sure there's no notes, just so we're there. If I have any concerns, many times there's no concern. But think of it still, you're in the court. So don't say, oh my, I'm on Zoom, I can't. Well, if you have a concern, the concern should be raised that I need to have these protections because that's what would be happening in court, or if we had a court reporter right there or the like. So we use the technology not to substitute what we're doing in court. We're using the technology to enhance what we're doing and utilize and expand where the court is. But so I've heard that from a number of lawyers that say, wow, what can I do? If you have concerns, stop the deposition, say, hey, I need to have some assurance that this is happening. In the trial that we had one witness that we, for reasons don't need to go into, but they wanted to make sure that witness was not seeing the exhibits beforehand and they were going to look clean. And they were sent to that person. They had a verification. They had to open it up on Zoom and it all worked. So again, you would work through those same issues if you were in court, or if someone was in California taking the deposition, you would work it through.
Perfect.
Awesome.
So I think we're over time, but I don't see any other questions coming through. If one comes through, I'll ask it. But I think at this point, Judge Ackert, thank you very much for coming today, giving us some answers to the questions that we're having. Same to you, Judge Groner. Always a pleasure. And then Mike.
Yeah, thank you, John. My own parting words, of course, I have to say something. I want everyone to understand that obviously this topic we could have talked about for days. Judge Groner and Judge Ackert and John and myself had that conversation. We knew that this topic would likely be a cram session. So what I'd like everyone to understand is that the Michigan, at least as far as the Michigan Supreme Court and the Lessons Learned Committee, and as far as the Michigan Defense Trial Council, I want everyone to understand that this is not the end of the discussion. We're in the beginning to mid stages of this. So please don't think that if there was something we didn't discuss, or if there was something that you didn't get a chance to kick a question out, or it's going to come in later, understand that as far as the MDTC is concerned, we are going to continue to monitor and continue to update our membership on these updates. And I hope Judge Groner, Judge Ackert, I hope you both don't mind continuing to be a resource for the MDTC and its membership, so that if we do get another question down the road or some sort of an update, if you don't mind, if we could reach out to you. The appreciation that we have to you both for giving up an amount of time, is your time is clearly more important than mine and probably John's, that we really do appreciate it. And we don't want this conversation to end today. We want it to begin today. So thank you both. John, thanks for doing an awesome job. Madeline, Matt, thank you both for being here. And everybody else in attendance, thank you guys. Thanks for the questions. They were great. And please don't be shy. If you have a question, concern, or if you're upset with something that you heard, blame John. And you can, I'm kidding, but absolutely. Our emails are open. Our phones are open. And again, thanks to everybody else. And I hope everyone has a safe new year.
Thank you.
Dude, thank you. Thank you, Mike.
Take care, everyone.
Thank
Thanks
you.
everyone
Stay
for
safe.
attending.
Thank you.